And will he waive the formal reading of the indictment?
So waived.
Mr. Blanchett, in cause number 25 DCCR 0799, the state has elected to proceed on the lesser included offense of terroristic threat, a Class B misdemeanor, from May 21st of 2025. And how do you plead to that charge?
Yes.
Are you pleading guilty freely and voluntarily?
Yes.
And are you pleading guilty because you actually did what they charged you with?
Yes.
I have here on the tablet some documents that have your signature on them that the state has marked as exhibit number 1. Before you signed these, did you go over them with Mr. Kimler?
Yes, ma'am.
Do you fully understand them?
Yes, ma'am.
And do you understand, if I follow the agreement that you've made with the district attorney, that you'll be waiving or giving up any right to appeal?
Yes, ma'am.
And it looks like the agreement that you've reached is for a 2-year deferred probation. There would be a $500 fine, and you would be required to follow all of the rules and conditions of probation. Is that your understanding?
Yes, ma'am.
And are you a U.S. citizen?
Yes, ma'am.
State tenors number 1.
No objection.
It's admitted. Is there any evidence that Mr. Blanchett is not competent?
Believe it, sure. I haven't observed any.
All right, sir, I'm going to find that you entered your plea of guilty freely and voluntarily. Find that you're mentally competent and you understand the nature and the consequences of your plea. Find sufficient evidence to find you guilty. However, I'm going to follow the agreement that you made with the district attorney and defer all proceedings, place you on probation for 2 years. You're ordered to pay that $500 fine and to follow all of the rules and conditions of probation. If you do that, this is an excellent opportunity because you don't have this on your record and the conviction on your record. And at the end of the probation period, if you are successful, the case will actually be dismissed. You'll never have the conviction. The other side of that, however, is if you violate any condition of probation, you can be brought back into court, found guilty of the offense, and sentenced to jail for up to 6 months. Do you understand?
Yes, ma'am.
I'm handing you the trial court certification that shows that this was an agreement that I followed, and so you've waived your right to appeal. You need to have a seat here in the courtroom. Probation will call you up to her desk when she's ready to go over your paperwork, and she's sitting at that desk right over there.
Yes, ma'am.
So watch for her to call your name, okay? Good luck.
Secure.
I'm sorry. That was last thing I already lost it.
You in court.
Listen to come on the show.
Yes.
Oh, thank you. Well, because we're over trying to come. No, you shouldn't take it. Is it there? Did y'all find it?
Yes. Did you say Class A?
Class B.
Class B. Okay.
Sure.
No.
See, Mr. Kimler, you have Wayne Cummings.
Class B.
Yeah, got it. Thank you.
Right away we're seeing something important: waiving the formal reading of the indictment. That means the defendant is skipping the full readout of charges to speed things up. It's common in plea deals, but here is the real question: when someone waives formalities this quickly, are they fully aware of what they're locking in, or are they just trying to get it over with?
Good morning. Are you Wayne Cummings? This is 18-29640. It's a motion to revoke probation. And what is the announcement?
Furnace. There you go.
Judge, in this case, all the allegations are from, the arrest and pending case in Orange County. I think we draw up the list that we said it hasn't been brought to the Orange County District Attorney's Office yet.
Okay.
So,
All right.
I checked this morning. They haven't received it yet.
Okay. We'll just do a normal reset and see where we get at the next court date. Stay in touch with Mr. Kimler and your bondsman. They'll let you know when you need to be back. Okay.
I think for you, that's already.
No.
He has the GPS and wanted to work on it, and most of it, I guess.
He can work with the GPS.
You know,
I'm not going to, just based on what I know right now, the next court date, we'll see where we are if there's nothing with that one, but apparently that's had something to do with,
she hasn't put a restriction on having this up to what the bond conditions are in Orange.
Actually, she said the drive
Is it-
was allowed.
All right, so you can't do that. That's a condition of your bond here that you can't do that.
So I think part of my concern was the time of the arrest. Was it 4:15 in the morning in Orange, which was
Pause right there. This is HUG. When the judge confirms he's giving up his right to appeal, that means if something goes wrong, Latour can't just change his mind. Appeal rights are powerful safeguards in the legal system. Once you waive them in a plea deal, you're basically saying, I accept this outcome. Would you give up that safety net?
I don't think he had permission to be in Orange. So let me try to look and see here. Here we go. I set a bond. Mr. Kimler sent something in. I set that bond, and that have a GPS, cannot drive any vehicle, remain in Jefferson or Orange County,
Where are you working?
and have a handheld. Do you have the handheld breathalyzer? Okay. All right.
Where are you working?
Did you have in the house?
Where you work? You can work. You can go to work in Jefferson, Orange County. So
You just can't drive. You got to get a ride.
But did you have in the Tesla plant house? They had me on.
He wants to work in Travis County. Or
Not until I know. No.
okay. Yeah.
I mean, you've got a case pending potentially in
Understand.
Orange, so let's get that one figured out quick, and then we'll decide. Obviously, we want you to have a job, but we're not going to do that yet. Ryan Hodge, Mr. Kimler, it's the sentencing. This is Miss Malfino.
It's agreed.
My question is, did he plead to,
What the evading motor do?
but did he, it says here habitual felon on the PSI. Did he plead to the,
In essence.
that's what, I think, if I'm going to take it, I'm guessing y'all did because of the
Yes.
criminal history.
Yes.
So that if you violate it,
It'd
needs
be
minimum 25. Got it. Okay, just wanted to make sure.
She's pretty important.
All right, sir, you're Ryan Hodge. This is 24 DCCR 116.
This right here is the double-edged sword of deferred probation. It's mercy, but it's conditional mercy. Complete probation successfully, no conviction on your record, mess it up, jail time. That's the pressure cooker moment. 2 years of freedom balanced against one mistake. Do you think most people truly understand how strict probation can be?
7, Mr. Hodge was previously in court, entered a plea of guilty to evading arrest or detention with the use of a motor vehicle, pled true to prior offenses, making this for punishment purposes a habitual offender punishment. The agreement was for a 10-year deferred probation, $500 fine. I received the pre-sentence report. Has everyone had an opportunity to review that report?
Yes, Judge.
I have no defense has your
Any additions or corrections?
no defense.
Not a mistake.
And again, the agreement was he pled true to those offenses so that if you violate this probation, the minimum punishment if you are violated and you get found guilty would be 25 years. Do you understand? There's no negotiations at that point. That is by law what the minimum will be. Okay. Your criminal history does not make me feel very good about you being successful on this probation. But if you've changed your life, this is going to be your opportunity. If you haven't, you're going to have a minimum 25. It's that simple, right? So I'm going to find that you entered your plea of guilty freely and voluntarily. Find sufficient evidence to find you guilty. However, I'm going to follow the agreement that you made with the district attorney and defer all proceedings and place you on probation for 10 years. You're ordered to pay the $500 fine and to follow all of the rules and conditions of probation. Obviously, you understand what a good opportunity this is if you are successful.
And now the tone shifts. A motion to revoke probation is serious. That means the court believes someone already on probation may have violated the terms. Remember that second chance we talked about. This is what happens when the court thinks the chance was wasted. The stakes just skyrocketed.
Successful and you complete the probation. The other side, again, is if you violate any condition of probation, you'll be back in here, you'll have the conviction, you've already pled true to the prior offenses, and you'll end up with at least a 25-year sentence up to the rest of your life. It is important, you're going to be on the high medium caseload, at least at the beginning of your probation, and that's intended to help you, not hinder you. But we want to make sure you have everything that you need in order to be successful.
I think you live out of county.
Yeah, I live in Oklahoma. I have a great support system. I have a job.
They'll talk, you need to talk to probation about where you live, and they'll get it transferred to where you live. You just have to go over through the proper process to get that taken care of.
The high medium caseload, whatever. They have-
Yeah, or whatever stipulations I follow.
Yeah, I'm sure everyone has some type of more intensive probation, and that's what I'm going to order, whatever it's called in whatever county or state. There will be a substance abuse assessment done. If there's anything in the assessment that's done that shows that you need any type of treatment, you will be required to do that. Anything else that probation says, you're required to do it. I'm handing you the trial court certification that shows that this was an agreement that I followed, and so you've waived your right to appeal. You need to have a seat here in the courtroom. Probation's going to call you up when she's ready to go over your paper. Good luck to you, sir.
Thank you.
Yeah.
Mr. Lewis, you have, no, let's see, Mr. Lewis. Mr. Parker, Kyra Rogers. Morning.
Morning. Trip just got back from Breckenridge.
Who?
Trip,
Oh, did he?
like a week or so before you.
Good morning. Are you Kyra Rogers? No. And will your client waive the formal reading of the indictment?
Yes, Your Honor.
Ms. Rogers, in cause number 25 DCCR 0976, you're charged with the state jail felony offense of theft of service from June 5th of 2025. And how do you plead to that charge?
Guilty.
Are you pleading guilty freely and voluntarily?
Yes, no.
And are you pleading guilty because you actually did what they charged you with?
Yes, no.
I have here on the tablet some documents that have your signature on them that the state has marked as exhibit number 1. Before you signed these, did you go over them with Mr. Parker?
Yes, no.
And do you fully understand them?
Yes, no.
And do you understand, if I follow the agreement that you've made with the district attorney, that you'll be waiving or giving up any right to appeal?
Yes, no.
Do you also understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of
Notice how detailed these conditions are. GPS monitoring, travel restrictions, no driving. Probation isn't just don't break the law, it's structured control. The court is managing risk in real time. 4:15 in the morning arrest that raises eyebrows when someone's movements are tracked this closely. One slip can mean jail, fair supervision, or overwhelming restriction.
naturalization under federal law.
Yes, no.
And it looks like the agreement that you've reached is for a 2-year deferred probation. There would not be a fine, but there would be restitution in the amount of $2,536. Is that your understanding?
Yes, ma'am.
State tenders number 1.
Objection?
It's admitted. Is there any evidence that Ms. Rogers is not competent?
No, Your Honor.
Any reason not to go forward in
No.
restitution?
I know you're on her record's clean other than this incident.
So I'm going to waive the pre-sentence report, Ms. Rogers. I'm going to find that you entered your plea of guilty freely and voluntarily. Find that you're mentally competent and you understand the nature and the consequences of your plea. Find sufficient evidence to find you guilty. However, I'm going to follow that agreement that you made with the district attorney. Defer all proceedings for 2 years, so you'll be on probation for 2 years.
Okay.
You're ordered to pay $2,536 in restitution and to follow all of the other rules and conditions of probation.
Okay.
If you do that, this is a great opportunity because you don't have a felony conviction on your record.
Yes, ma'am.
And if you successfully complete the probation at the end, the case is actually dismissed and you'll never have that conviction.
Okay.
The other side of that, though, is if you violate any condition of probation, you can be brought back into court, you could be found guilty, and you could go to the state jail prison for between 6 months and up to 2 years. So you
Okay.
understand.
Yes, ma'am.
Also, it is very important. 2 years seems like a long time potentially to pay off that money, but it's going to go by pretty quickly.
Okay.
I want you to start making payments immediately. Even if it's a little bit, it'll add up.
Okay.
Because what can happen is if you don't make payments on that, and at the end of your probation period, I find that you could have paid, you could do 2 years of probation and still be revoked for not paying it.
Okay.
So make sure you get that paid, okay?
Yes, ma'am.
All right, if you, I'm handing you the trial certification that shows this was an agreement that I followed, and so you waived your right to appeal. You need to have a seat here in the courtroom. Probation's going to call you up to her desk when she's ready to go over your paperwork. She's at that desk right there, so kind of pay attention for her to call your name, okay?
Okay.
All right, good luck to you, ma'am.
Thank you, Your Honor.
Thank you. Mr. Parker, you have a sentencing on Allison Strawn. Yep. Seen her?
But I was at drug court.
Good morning, you're Allison Strong. And Ms. Strong was previously in court, entered a plea of guilty to assault on a peace officer. I've received that pre-sentence report. Has everyone had an opportunity to review the report?
I have, Your Honor.
Are there any additions or corrections?
None of my way, Judge. Not by stating.
All right, Ms. Strom, I'm going to find that you previously entered your plea of guilty freely and voluntarily. Find sufficient evidence to find you guilty. However, I'm going to follow the agreement that you made with the district attorney and defer all proceedings and place you on probation for 3 years. You're ordered to follow all of the rules and conditions of probation, including you will be on the mental health caseload so you can get whatever type of help necessary so that you can be successful on your probation. It's important that you follow all of the rules and conditions through the mental health caseload, through regular probation. If you do everything you're supposed to on this probation, it's a great opportunity because you don't have a felony conviction on your record. And at the end of the probation, if you're successful, the case is dismissed and you'll never have a felony conviction. The other side of that, though, is if you violate any condition of probation, you can be brought back into court, found guilty, so you become a convicted felon, and you could go to prison for anywhere in that punishment range, which is between 2 years and up to 20 years in prison. Do you understand?
Yes.
All right. I'm handing you the trial court certification that shows that this was an agreement that I followed, and so you've waived your right to appeal. If you'll just have a seat here in the courtroom, watch for probation. She's going to call you up, and she's ready to go over your paperwork. Good luck, ma'am. Yes, yeah, no fine. Mr. Parker, you got Lisa White.
Your Honor, I believe we've got,
Let's get Lisa White.
she's here.
Good morning, ma'am. You're Lisa White.
Yes, we good.
In cause number 25 DCCR 0923, Ms. White is charged with aggravated assault with a deadly weapon. And what is the announcement?
Judge, I'm having issues with contact with the complainant. I'd ask for one reset. Well, then I will issue a subpoena and do a bailiff's call there.
Okay, sounds good. We'll do a normal reset for that. Ms. White, stay in touch with your attorney, with your bondsman. They'll let you know when you need to be back. All right, thank you. You're free to go.
Thank you.
Thank you.
Note that note on
This might be the most dramatic moment of the entire docket. 25 years minimum if he violates. That's not a warning, that's a legal time bomb. As a habitual offender, prior convictions enhance punishment dramatically. Probation here isn't just a second chance, it's possibly the last one. 10 years walking a tightrope. Would you call that mercy or a countdown clock?